If John was beaten up and attacked in that house, who did it?
Just because you didn't do it.
We know who did it. We know.
Okay, you're aware he was beaten up by Bryan and Crown Albert. I mean, we're all in on the same joke, right? My tail light was cracked and John was pulverized.
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Memories of laughter and tears. In the silence they appear, whispers of a time so true, when love was all we knew. Lost in the echoes of the past, wishing for what we had. In the dark, we search for light, holding on to what we fight. Through the pain, through the night, we find strength in the fight. Sorrow in the guitar's cry, resilience in the sky. Through the night.
Hey guys, just setting it up. So we will bring on the hearing at 1 o'clock. I wasn't, as of last night, planning to do this, and then I saw that it was on Court TV, so I figured I'd bring it on for people from our crew that want to watch it with us. And I sent out the invitation to the panel late, so I'm not sure if anybody will be coming on, but if they are, the invitation was open. So we had a good. Let me just finish setting this up. So we had last night a very good guest on the show who had lost her son to murder. And I don't know the details of the case. We just know what she talked about last night. She was a very articulate spokesperson. She is a former corporate executive that spends her time now speaking out as a victim's advocate, and which means she's an advocate for the families. And that comes in all different types of forms here, right? If you have a case where the case remains unsolved, that's obviously the worst form of injustice for the families. Because the stress of not knowing who killed your loved one and to have to live with that is just, it must be torture. In the case of what Christine went through with her son, they knew who the killer was. It was someone who had bragged about it. But it ended up being an ordeal that took years to get through. And at the end of the day, they only got through it by finally working out a plea deal. But probably a little bit different circumstances than we're seeing here in the Kohbeger case. In that case there, she expressed how she was willing to accept a plea deal because she no longer trusted the prosecution or the system, the judge, not just the prosecution, but the judge in this state. So she came away with a perception that the criminal justice system in the state of Massachusetts is completely unreliable. You can't count on it. So if it's not there to successfully prosecute killers, then it's not really there for the victims' families either. And she only got some reaction when she finally reached out directly to the then Attorney General, Martha Coakley. And so that, the squeaky wheel gets the oil, right? So once you make yourself outspoken on that, and especially where she's very articulate herself, and at the time would have been a corporate executive. So that's the kind of thing that makes politicians react. And that's what happened here. And they did react. Put this on full screen. All right, so let's check in and see who's here. I have to talk. I'm going to turn. Let me know how the audio is. I'm going to turn up the gain just a little bit because I want to speak softly so as to not bother other people in my house. So let me know how the volume is now. If you guys could, Thomas, if you're here, how's the? I see you there, Tom. How's the volume sound? Am I doing okay? Thank you, Lori. If that yes is to me, thank you. Audio is clean. Thank you, Tom. All right, thank you, Joe. We have a couple of Joes here. A couple of J.O. Joes. Someone's asking about the Bryan Walsh trial. And hi, Maui. I don't know. I haven't made any decisions on that. So the big thing that I'm working on now is the cold case desk. And we're getting the website set up for that. And we're going to start planning shows around that. And we have a lot of different people that are willing to help out with this. But the idea is to try to bring attention to cold cases. Some of them would be famous cold cases that a lot of people have heard of. But other ones that people are reaching out to me to cover are cold cases that were never famous, where they're forgotten for one reason or another. And so, hi Wiccanuma. And so, we're going to seek out those cases too, because we want to try to bring. Ultimately, we'd like to help solve a case, right? But that's hard to do. Or we'd like to get information we'd like to produce some kind of information that we can get to the police that helps them solve a case. That's the upper end of our hopes. That's the ceiling, so to speak. But more realistically, that's hard to do. What we do want to do is just by bringing attention to a case that hasn't been talked about for a long time, that in itself gives a lot of relief to the families. So that's something we want to do. And so, we're seeing here too, and thank you guys for being here with me. Now, what you guys are seeing, this is a phenomenon that I understood for the last several years, certainly the last 2 years, is that trying to be the calm, when it comes to the game of the internet and trying to build an audience, trying to be the calm, balanced voice of reason is not a good marketing strategy. A good marketing strategy is to take the extreme of one side or the other, because that's how you develop entertainment content, right? And just human beings naturally kind of tend to go to one echo chamber or the other. And so the people that are here are going to hear a very different type of discussion than they'll hear, for example, on Roberta's channel. And so if you just want someone that is 100% going to say everything on one side, and that's going to tickle your funny bone and it's going to make you feel good, those are the places you'll go. And most people will go to those places because they just want that reinforcement of what they already believe. And that's what they want. It's just like the same with politics. If you're a liberal, you're going to go to an extreme liberal website. If you're a conservative, vice versa. You're not going to go to one of those sites, but very few people want to go to that site that's kind of down the middle and tries to be fair. There are some, for instance, so I think The Daily Show with Jon Stewart, I don't know if I would say that was fair. Jon Stewart is obviously very liberal, but at least he's willing to hit both sides and do it with a lot of talent and a lot of humor. So I always thought Jon Stewart did a pretty good job. I think Bill Maher is another example of that. He's a liberal. He's a self-described liberal. But he does try to be fair and hit both sides. And I think that's really important. And what I've always said is if I'm not pissing off everybody once in a while, then I'm not doing it right. But it's not the best way to get numbers. And of course, in this case here, the ultimate best way to get numbers was to play the conspiracy angle. The public thirst for cover-ups and conspiracy cannot be quenched. So had I stayed that course, I'd have thousands of followers. And I was on it. I was the second person on it. I was on it right after Turtle Boy. literally a week after. So that was I chose to go, as I always would, to keep asking hard questions and trying to get to the truth. But the other guys that didn't do that, they've been rewarded. And that's the way it goes. So I hope that people on our side understand that. I do kind of wish that people within some of the witnesses would say, you know what? This guy's paying a price for being honest, and recognize that we got to kind of help keep him afloat. But that's up to them. Okay, let me just check in chat. Oh, Daniel Bush. Thank you very much for the donation. Says, glad to be back. I wish these families peace. And I'm not sure if we're talking about, well, all the families, right? All the families of the victims. So in this case here, this was going to be the Bryan Kohbeger hearing. And certainly at least one of the fathers, I think it's Gonzalez's father, Goncalves, I don't think I said her name right. He's unhappy with this plea deal. And, I can understand why. And I think it also wasn't handled well. They didn't communicate. The prosecution didn't communicate properly with them. But I also will say that I do think the investigation, as far as I could see from when I was following it very closely back after they first caught Bryan, the investigators really should be commended that caught Bryan. As far as I can tell, they did an outstanding job. They really did. Now, we shouldn't try to compare that to, for instance, the Karen Reed case, because the urgency of the investigation in the Kohbeger case was going to be 1,000 times more, because you had 4 kids that were slaughtered by an intruder who came into their house, 4 college kids. So the hunt to catch that killer was going to be extreme, urgency, all hands on deck kind of thing. Whereas in the Karen Reed case, it was within hours viewed as just an ordinary hit and run case. So you wouldn't expect to see the level of law enforcement professionalism, or I mean, that's the right word, or I think urgency, I guess, is the right word. You wouldn't expect to see that in the Karen Reed case. So it's 1:04, and as you guys know, you never know for sure when these hearings are going to start. How do you guys feel about the death penalty? Now, it's not as controversial as saying, how do you feel about abortion or something like that, because we're discussing true crime, and this is a situation here where Bryan Kohbeger, had the plea deal not been worked out, would have faced a death penalty if he was convicted. So how do you guys feel about the death penalty? Lori is all for it. Allie doesn't believe in the death penalty, too expensive and ineffective, and those are good points. I used to be 100% pro death penalty as long as the evidence was strong enough. I flipped my position on that in the 90s. I watched a documentary on the Discovery Channel back then. So this is like 25 years ago. It was their old big narrator, Bill Curtis. And what this documentary, I don't remember the details, but there was a massacre that took place at like a Buddhist temple or something like that. A massacre, like dozens of people killed. And they eventually caught these 2 Hispanic guys that had come over, 2 Mexicans, Where this killing took place wasn't far from the Mexican border either. And these two Mexicans actually confessed to the killing. And they were convicted, sentenced to die, and they were on death row when evidence emerged in prison of the real killers. And then it turned out that these two Mexicans who had confessed had weren't even in the area. They were hundreds of miles away. They had a foolproof alibi. And so why did they confess? Well, it turned out that teams of detectives were grilling them round the clock. I forget what the amount of time was, but it was a very, very long time. Hi, Kyle. Thank you. And so around the clock, they were getting grilled. And under those, and so each successive team that would come in would accidentally give some information about the crime scene to the suspects. And then later on, when they were being grilled by other detectives, they would know some evidence from the crime scene, but they only knew it not from being there, but they had been unwittingly given that information from the other detectives. So they've done studies on this since then, or even leading up to that show that human beings, if you grill them for 24 hours and you don't let them sleep, their minds break down, and they eventually, until they get some sleep, can convince themselves that they did it. And that seems to have what happened here. And so they were let go. But it was close. They were on death row for a few years. And when I looked at that, I realized, there's so much pressure on prosecutors to get a conviction in a case like that we should be a little alarmed about whether or not through their rush to justice, they might have the wrong person and put pressure on them. I don't want to say it's deliberate, although in some cases it could even be at least partly deliberate. So after I saw that, I kind of was like, yeah, there's too many mistakes out there. So at least if you're convicted and you're in jail, there's a chance that it's reversible if the truth ever comes out. So I became okay with sentencing people to life as long as that sentence means what it says. You can't sentence someone like in Europe. They sentence you to life and it's only 14 years. They're extremely liberal in Europe. And I've reviewed some horrible cases on that. I think that most of the European countries have some kind of a maximum where no one can go in jail more than 14 years. If we have any Europeans here, they can talk to us and maybe tell us. Usually we have like my friend Marius from Norway and stuff like that. But we had a few. It seemed like we had a few less Europeans during the trial this time, or maybe that's just there was so many people here they got a little bit lost in the shuffle. But if we have any Euros watching today, let me know how you guys feel about your death penalty. I'm gonna refresh this to make sure we're not missing anything. No, still all right. So did you guys happen to watch any last night of the David Yannetti and Bobby Alessi on Canton Confidential? I was a little bit late starting the show last night, or if it seemed a little rushed, that was the reason. Nima, of course you are from Sweden. Let us know about the death penalty there in Europe. Is it real? How's the sentencing look there? Do you have any confidence in it? Yes, Steve, all is well. So, I was there in time to see the reporter ask. He was on. There was two reporters on with. There was Sue O'Connell and the other guy, I forget his name, and he asked David Yannetti about his involvement with Turtle Boy and the witness intimidation. And David Yannetti's answers were so dishonest. There's no other way. You don't want to personalize these things, but I'm sorry. He's a foul human being. And it bothered me, too, that he's allowed to put this dishonest answer out there that is just not supported by the facts. And he should have been pressed on that answer. But instead of pressing, the next goes to Sue Question and Sue Kohbeger. Sue O'Connell. And of course, she's not going to push back. No, because she's pretty much part of the defense team. So she went right on to another topic that was a pro-prosecution topic. I forget what it was. And so you finally get them to ask a question, and then he doesn't give an honest answer, and he should have been pressed on it. So, for instance, he compared Turtle Boy to 60 Minutes. He said, well, there's nothing wrong with just walking up to people's houses to ask them a question. Come on, man. This is where Sue O'Connell, if she actually was an honest reporter, would push back and say, wait a minute. The rolling rally had over 100 people stopping at these houses with Turtle Boy with a bullhorn, calling them murderers. You want to compare that to 60 Minutes? And there's evidence that Yannetti knew about that, and that Karen may have helped in the planning of the rolling rally. And we know that the next day after the rolling rally, because we know this from Turtle Boy, because he was recently upset about it. Turtle Boy, Matt Gutman from ABC, David Yannetti, the other Alan Jackson, and Karen Reed were all at a dinner the day after the rolling rally. Now, there's no way that they didn't talk about the rolling rally. There's no way. It was a huge event. So why doesn't Sue O'Connell ask that question to David Yannetti? Again, she's not an honest reporter. She's not trying to get to the truth. She's a turtle rider. That's all. And I'm sorry if people think that's unfair. Like if she was listening to this now, she'd say, you just want me to be one-sided. No, I want you to push back. That's what a reporter does. Okay, because there's a lot of ammo here to push back on. Talk to Yannetti about the dozens of phone calls that were captured in the phone records between Yannetti and Alan Jackson and Turtle Boy as this story was breaking, as they were feeding it to him. Talk about that. So, I mean, this defense team has used the ignorance of the mob through a turtle rider, through Turtle Boy himself, in order to get their client off. Is that within the rules? At least discuss it. Don't discuss it dishonestly. At least say, hey, anything that's, if you want to take the position, David Yannetti, that everything that's legal is within the rules, is within the rules and is ethical. If you want to take the position that everything that is legal is ethical, then just come out and say that. Come out and say that. And go on a real show, David Yannetti, that you'll be asked questions, not one with Sue O'Connell there to protect you. Leafy, is it starting up? The Court TV feed is always, well, at least on the Karen Reed line, was always about 30, 40 seconds behind. So that's probably going to be the case here too. Just refresh it to make sure. Yeah.
It will come to order. General Stephen Hitler, presiding judge. Let me see it. All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye. Here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well.
Ms.
Your
Allen
Honor.
is here as well. Very well. Thank you. All right. We are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this, because again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom you, many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in a matter not pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Kohberg, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As as I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Is anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously, there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document? And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count 5, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohbeger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohbeger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m. on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Latah County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. on the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohbeger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohbeger's name, Bryan Kohbeger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohbeger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and Caitlin Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were two other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom were to see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, this Sunday, the 13th of November of 2022, Mr. Kohbeger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th, 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohbeger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohbeger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohbeger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogan's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohbeger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. You can try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohbeger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogan, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
Thank you. All right, based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohbeger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. Court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties or the next week, the week of August 4 is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor. Thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through
All right.
sentencing.
I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor. Thank you.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned. All right, please.
Okay, hey guys. So I don't think we really learned anything new there about the crimes. We did learn there, and this may have been already known, but I'm not sure. I'm sure certainly Daniel would know it from Drunken Turkeys. But we'll get rid of this. Sorry about that. Ordering on a previous question. This is on Court TV too. I don't know why that went in there. Huh. Why is Court TV going into a congressional feed? Now it's got my curiosity. Because like I said, see, this is Court TV. Why did it go into that feed? All right. So let's just assume it's over. We did learn that apparently Kohbeger killed Xana when she came out, perhaps to get her food or something. And he was coming down the stairs just as she opened the door there. But it sounds like that her boyfriend was asleep in the bed and he didn't wake up. So after killing Xana, Kohbeger went into the room, went out of his way to go into the room to kill him in the bed. And so I did a series on this before Kohbeger was named, before he was arrested. I forget how many parts. I did several parts series on this so this is going back a few years ago. And at the time, the police spokesman, and like I said, I think the police did a great job in this case, although the spokesman made some really unfortunate, inaccurate statements in the early days afterwards that he had to retract. But one of the things that they were saying was that this was a targeted killing. And I heard a lot of people go on various YouTube platforms, including Pat Brown, saying things like that. And I was annoyed by it because I guess we can quibble over what the meaning of targeted is. But you can go back to my old videos. And what I said is that this was a budding serial killer. And it didn't seem to be that few, if any, of the experts believe that. They all believe this was targeted. Now, it may have been targeted in the sense that we may never know that Kohbeger may have developed some obsession over one of the girls, for example. But what I understood targeted to mean is, and they were saying this in the media, that maybe this was a drug deal gone bad and the drug dealers came back to take revenge or something like that. And I didn't believe that at all. Because to me, if you went up to the third floor, and at the time we didn't know where the killings were done first. So if your target was on the third floor, why would you begin up there and then come down and kill more people on the second floor? Or if your target was on the second floor, why would you go back to the third floor after killing your target on the second floor? So to me, I always believed, based on that type of, and the fact that other roommates were left to live too, all of this was consistent to me with somebody who was a serial killer, but perhaps killing for the first time, but still a serial killer nonetheless. Someone who was killing for the pleasure of killing. Someone who would have got a lot of pleasure from the stalking of these people. And I said in my early videos, he's someone that would have been hanging around outside of the house on other nights, going to parties there. That was all part of it, right, Maui? Stalking. So they get, if you read, right now I'm reading John Douglas's book on the BTK killer, but this is consistent with what I've read on other things too. Is that these guys get the biggest. So the psychopath is naturally short on dopamine. And, but when they get the stimulus, the dopamine release in their brain is 4 times higher than that in a normal person. And when it comes to their killing, when they're getting the most dopamine release is not from the actual killing, it's from the stalking, it's from the hunt. And BTK killer spent years developing these fantasies around hunting. And in those fantasies, he wasn't killing anybody, actually. It was the hunt that was what, and he'd go out on, when he was stationed at a military base in Japan, he'd go out kind of mimicking the hunt in these little Japanese towns and stuff like that. And that's where he's getting the chemical rush. That's where he's getting the dopamine fix for. So Maui Swift is exactly right. It's the hunt that really does it for him. Why did the prosecutor say there was no evidence of stalking the victims at a hearing last year? I don't know. You'd have to ask Dan. I didn't follow. Like I said, to me, I'm interested in unsolved cases. And once the case is solved, and when I read the early reports over the first few weeks on what evidence they had against Kohbeger, I was like, yeah, this is it. They got the guy. So I haven't followed it that closely. Drunken Turkeys, Daniel obviously has. So he'd be able to answer something like that. So, in terms of, Jen is actually here. Oh, Jen made it. Hello, Jen. Oh, Jen was here. She's gone. So I think she just popped in. I think she just let her audience join us. Sorry, Jen. I didn't mean to spook you. Oh, she's back again, I think. Oh, she's trying. Jen,
Hey
you
there,
here?
Kevin.
Hey.
Yes, I am. How are you? I think I can answer some of those questions.
Please, yeah.
Remember, there are, if you can hear me, there's different definitions of stalking, right?
Right.
So in the actual definition of stalking, where you're discussing somebody who wants you to know they're stalking them, they are
Right.
literally calling, hanging up, they are getting off on torturing you by stalking
Right.
you. That's different from surveillance, from site surveys, from preparing to commit a crime. And so
Right.
I believe that's why very specifically Bill Thompson said in a hearing early on that we don't have evidence of stalking. He's going
Right.
from the legal definition, not
The legal definition. Right. Right. You kind of went to robot voice for a second. We'll see if we get her fully back in a moment. Jen, are you speaking or don't actually? So if you are talking, you got cut out. Not hearing anything.
Oh, sorry. Can you hear me now?
Okay. Yeah, you hear?
Yeah.
Yeah, you sound good. now.
Kohbeger wasn't stalking in the sense of like calling and hanging up and hanging
Right.
outside their windows so they could see and stalking from that aspect. He was surveilling
Right.
their properties. He was preparing for this. I also wanted to comment about your hunt analogy. Remember where BTK as an example, his climax was after the crimes, actually ejaculating on his victims. So that was the climax for him. Obviously, the hunt was very exciting, but the climax was certainly when the crime was successful. And I think BTK or Bryan Kohbeger's plan was to kill Maddie Mogan and sexually assault her, and that was thwarted when Kaylee Gonzalez, who had already moved out and wasn't supposed to be there, and he hadn't done the appropriate surveillance that night to know she was back, and even if he would have, she had changed vehicles.
Right.
So in any event, I just wanted to kind of chat on those 2 points.
Yeah, it's an important point. And even also in terms of BTK, what I was saying was that the time when the greatest amount of dopamine is released is during the hunt. Now, that may not be exactly the same thing as the climax too, so yeah, he did famously after it was over ejaculate on the victims sometimes, but there's there's different levels of what that may not be the same thing as the dopamine fix, but the main point is they do get tremendous, and this is where they build up early on before they reach the point of acting on their fantasies, is they spend a lot of time hunting people, at which surveillance would count as that. Exactly. So he did surveillance of this house going back months, and they talked about that a little bit in the hearing today. How they knew that based on his phone that he was in that area.
Yeah, about 30 times. And I tell you, Kevin, the most disappointing part of this hearing, most disappointing, and it was reported on earlier that this is what we could expect, but he gave no details. It wasn't like when Dennis Rader had to speak on his crimes or many other people in court. His statement was simply Judge Hippler stating something and him agreeing. And that is so completely disappointing. The fact that apparently he's not going to have to say where the knife is, where the dirty clothes is, he's not going to have to provide any more information, I'm convinced is because he's going to do book deals and he's going to do interviews, and so he needs to save all of that for those. And remember, there's no son of Sam laws per se in Idaho, although there are restitution laws for these types of victims. It's just really disappointing. I wish they'd lock him away and nobody would ever talk about him or look at him again.
Is there a chance to, and I know it doesn't sound like it because at least they could have asked, like you said, basic defense, the details like where is the murder weapon. But is there a chance that they didn't want him to have that BTK moment, and that's why they didn't want the allocution? Because
I don't
BTK,
think
really
so.
went off for he put on a performance. That was like the highlight of his life there. That performance that he put on in the courtroom, that just really made the family suffer all that much more.
It was. It was like being a valedictorian, finally getting to say your speech.
Right.
That's what it felt like. I'm from Kansas, lived 5 miles away from him, and it was quite a moment for him.
Right.
I don't think that was it. I think, in fact, a big point has come up that I think is true. What has he provided that's separate and independent from what the state knows? Obviously, the state has amazing evidence, but if he
Right.
could have said, yeah, this is what I did with the knife, which of course the state is pointing out, he probably threw it in the river. I mean, that was
Right.
what they trying to lead up to.
Right. Well, so do you think the families feel any more or less satisfied after the hearing today, or probably just status quo because it's exactly what they expected, and if they were already unhappy with that, then that's what it was?
Well, the Mogan family definitely is happy to get this behind them. They released a statement, which I thought was very important. Ben Mogan and just saying, listen, we're ready for it to be over with. We're done. And then of course Santa Granodal's aunt very upset. Obviously, Steve Gonsalves very upset. And in fact, my understanding is he did not go into the courtroom. He waited outside, and so he likely doesn't even know what was said or wasn't said. But this was certainly pro forma, exactly how other pleas I've seen have gone, except for I would expect something this high profile for his statement, Bryan Kohbeger's, to have been at least somewhat his words, not the judge's words, and him to say yes. Very disappointing.
This may have been something you guys already knew, and I didn't know until today. But apparently, Bryan killed Xana in the doorway. And it sounds like her boyfriend didn't wake up. And then Bryan proceeded to go into the bedroom anyways and kill him in the bed. That's what it sounded like.
Yeah, that's something we've known for a while. The Dateline special, and again, Dateline has gotten in some trouble on this point. I don't know if Dateline, I should say, hasn't gotten in trouble, but whoever leaked that information is going to be in trouble. There's a separate investigation with a separate staff allotted to trying to figure out where that leak was. Remember, everybody was under gag, and this was clear insider information from either the prosecution or from the police officers. And they disclosed all of that she was headed up the stairs, and that's when Bryan killed her. And so really more like toward her doorway, Kevin, just so you know, not the doorway of Maddie and Kaylee.
Right.
And furthermore, he did go in there and furthermore cut up his legs in a very sinister and maniacal manner for no reason that would have been necessary.
So basically mutilated the body after killing him?
Yes.
Interesting. Well,
Just
I mean,
Ethan.
that just, so to
That
me,
we know.
if the police, obviously they understood this from the get-go, then they should have understood that what they were dealing with was someone who is either a serial killer or a budding serial killer who his motive was to kill for the sake of killing. They didn't seem to understand that, though, in the first few days. And if they knew that he went out of his way to, after killing Xana, to go in and kill the boyfriend in his bed, you don't do that unless you're killing for the pleasure of killing.
Right. And just to go back to some of those initial statements, Kevin, at the very beginning, the chief, he made the mistake of saying this was quote unquote targeted, which of course, then everybody thought, oh my gosh, it must be somebody that actually knows them, right? A mad boyfriend or angry. That's how we all took that. But then in an interview with Brian Enton, shortly thereafter, he had an interview with Bill Thompson, the prosecutor. And the prosecutor said, well, this wasn't really targeted. We think the house may have been targeted, words to that effect. And then, of course, I think most of us knew, and I think most of us knew anyway, this wasn't targeted in the sense of a boyfriend or something like that. This was far more sinister. This was a mass murder.
Right. Yeah, that's definitely what it seemed like. Yeah, that's how I took targeted to mean back when they said it. So you're saying it was just maybe not the best worded press conference.
Right. And
Yeah.
and I think he was so concerned about panic.
Yeah.
And there's little town, and I think he was so worried about that he tried to make it seem like nobody else was in jeopardy. But as I always say, when there's a murderer out there on the loose, people are in jeopardy. Yes.
Yeah,
You know?
yeah. This seems to be some gut instinct on the part of local police officials to do this. This is where I got my first experience of true crime in my life, and then also got me started on discovering on this channel. So when I was a 10-year-old kid, and growing up in the city of Lawrence, in old Milltown in Massachusetts, there was another 10-year-old kid who I didn't know, but he went missing, and he was last seen by a state pool. The kid was from the projects, and it was a big deal at the time. So they brought in the National Guard and the Green Beret and all kinds of stuff to go looking for this kid. And the city shut down for several days, and then all of a sudden, everything stopped. And the police put a headline that I still remember inside that smashed across the front of the paper saying, "We have reason to believe that the kid's name was Andy, that Andy is with family." So the police basically announced there was nothing to worry about. Andy's with family. Now it turns out, and the public learned this several years later, that the police made that up. They had absolutely no evidence that Andy was with any family anywhere. And Andy's never been found. But so that was one of my first experiences with real true crime as a kid. And then as I watched a documentary on this a few years ago, and it got me kind of doing true crime on the channel. But yeah, that seems to be a common thing in a lot of towns where the police just don't want the town. They put such a, think back to the movie Jaws, when the town didn't want to lose the summer crowd, and they were like, all right, we have reason to believe the shark has been caught or something like that. I forget how they did it there, but that seems to be a big problem.
Yeah, this was, for most of us that were covering this from day one, we all said, listen, this town is not safe. And at all, there's somebody who committed 4 murders that is likely not affiliated with the children in terms of, it being a jealousy or, some sort of anger,
right,
specifically for one of those kids.
Right.
So, yeah. And then finally, they had to sort of say, geez, we got a mass murder on the loose. And,
yeah,
it took 5 weeks, by the way, to get him in custody.
And they did do, from everything I saw, a really fantastic job in the actual investigation to catch Bryan Kohbeger. Do you agree with that? That they did it? The police did a good job.
Yeah, I did. Look, there were 60 FBI agents, literally agents. I'm not talking about support and analytical help, because that's probably numbered in the hundreds throughout the United States, particularly when they were trying to track down the vehicle. And they were all tasked with that. I've been involved in those. Where, it happens quite often during surveillance where you get a partial tag or you don't get a tag, and you get the whole analytical team just trying to sort out how many people have a white, Hyundai, Elantra, and then you start narrowing down from there. It takes quite a lot of manpower and analytical work, but you basically had huge resources in the FBI that were committed to this case. The officer assigned had only about 2 years, even being a police officer.
Yeah.
So I've always maintained that this case was largely run by the FBI, and, mentoring him with, Moscow maintaining venue. But yeah, it was well run. I agree.
And the prosecution today did thank the FBI.
Yes, I was so glad to hear them say that, because literally 60 agents who drop everything they're doing. They have cases, they have things they're doing, and you drop and you work on these murder investigations at the drop of the hat, because you have a community that's in possible peril with somebody on the list. One of the things that they said, though, there were 2 things that I had never heard before. And one thing was about the car. So most of us who have, we're talking about this case, as I said early on, we said there's no way they could cover up the blood evidence that some hair, one drip of blood is just so hard to clean that well. And we were all wrong, all of us, because he was able to do that. But if you listen, which I've never heard them say, they said he dismantled the interior of that car.
Right.
And that makes a lot more sense to me, having sort of a stripped vehicle that you got rid of anything. And of course, the paper that he wrote on crime scene investigation that we went over ad nauseum. I did a whole show on it. He knew exactly. And guess what? The the fictional story that he had for his paper involved a knife. I always thought that was telling.
Yeah. All right. Well, Jen, thank you very much for being here. I think I'm going to end this here unless there's anything else you want to mention.
No, I want to thank you so much for streaming this. I know this wasn't particularly something that was in your priority. It's out of your jurisdiction, but I appreciate you giving this an audience because it was just for many of us the most important case maybe we've ever covered. So thank you.
Right. No, it's definitely a big case, and I knew the audience wanted it, so I figured I once I knew I had time today and it was going to be on Court TV's feed. I said, and they had camera. I didn't know if there'd be cameras in the courtroom, but I learned that this morning, so I set it up. And for everybody here, we have such an intelligent audience, and they obviously bring a lot of evidence and to cases that I might not be following, or you not in this case, but there might be another case that you're not following as well, but they might be following, and they can bring us evidence. So it's very helpful. So I appreciate them, and I appreciate you.
Yeah, I love your audience. Thanks again, Kevin, and it's Red last night as well. You take care. I'm thinking about you.
Okay. Thanks, Jen. Talk to you soon.
Bye.
Okay, guys, that was Jen from Breaking the Case with Jen Coffenaffer. I'm sure by now you all subscribe already, but if not, please head over there and do that. And unless anybody else has a question, we're going to call this a day. Oh, I will just briefly, everybody, I guess the big topic once again yesterday was this idea that the flooring from 34 Fairview, they're somehow suspicious about this, that the Alberts had flooring removed. Again, this is the thing. I just wish people had a little bit of common sense. That's the thing that bothers me, and especially about the FKR people. The way that story is told is that Turtle Boy himself was driving by the house. So this would have been about a year, or more than a year after the Alberts moved out of the house, and a year and a half after John's murder. And he's driving by and he sees a van out there, and this material being moved into it. So he contacts the defense, and they get a hold of it, and they find out that it says flooring. But what bothers me is that if the contention is that the Alberts had taken out this flooring in the basement and left it somewhere in the house, and the new owners had to remove it. So in Free Karen Reed world, they actually believe that the Alberts took out that flooring because it had blood on it, but then failed to have it removed from the house. They left it in the house for the new owners to deal with. And that just doesn't make any sense, right? I mean, if you're a murderer and you sell your house and you've dug up the floor, you're going to make sure you get rid of that flooring. But they don't seem to ask questions like that, which really surprises me. But in any case, the flooring was connected to a toilet in the basement that kept overflowing. Now, I can tell you we've had this in the bars that I owned. It would be a problem with overflowing. And when that would happen, occasionally you'd get this rot underneath it. And so the toilet is built on a structure of wooden planks. And those planks can rot. And so it sounds like what happened because of frequent flooding there is that the Alberts lifted up the toilet and found that those planks were rotting. And so they took them out and then replaced it with some rubber mats. So then later on, when the new owners were in the house, they found the old planks somewhere, had been stashed somewhere, and they were getting rid of it. But again, if you're in Free Karen Reed Zombieland, why don't you even ask if it makes sense that the so-called killers, would leave behind this evidence that has this material that has evidence of a murder on it? Why wouldn't they get rid of that? They don't ask questions like that. It's just, and on we see that over and over again. And you notice that none of that evidence did the defense use at trial, but they're still bringing it up as though there's something there, which is just amazing. No. All right, guys. It's a nice hot day out. Go, if you're living around here, go outside, get some sun, walk the dog. If you're like Tom Fleming, go chase down the ice cream truck. Have a good time. Enjoy the summer, because we've turned the corner. We're now a week past the summer solstice, and now the days get a little shorter every day. And we're getting a little bit closer to those long, dark days and snow. So thank you very much for being here, everybody, and we'll talk to you soon.